Ho, 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 welcome my ambitious legal scholars. I'm Professor Albert J. Legalis, Dean and founder of Legalis Law School, and I have wonderful news for you. You see, here at Legalis Law School, it's always Christmas. Every day of the year, we're in the business of giving gifts. The gift of legal knowledge, the gift of professional competence, and the gift of confidence in the courtroom. And today's gift is something that will save you from costly procedural mistakes. A complete guide to mastering New York civil procedure from filing to trial. Whether you're a pro se litigant fighting for justice, a junior associate building your skills, or an experienced attorney expanding into new areas, this course is my personal gift to you. Now some people say, Professor Legalis, why do you give away so much valuable legal education for free? And I tell them, because knowledge is meant to be shared, because justice requires educated advocates, and because every lawyer who succeeds makes the entire profession stronger. So consider this course your early Christmas present, your late Christmas present, or your everyday Christmas present, because at Legalis Law School, the spirit of giving never ends. Now let's unwrap this gift together and dive into today's course. You're going to love what we have prepared for you.
The number one reason cases get dismissed in New York: improper service of process. I'm Professor Sarah Chen, former New York State Court Administrator, and I've seen more winnable cases lost to procedural errors than I care to count. Let me save you from that fate by teaching you the fundamentals that separate successful litigants from dismissed plaintiffs. First, understand that New York is different. While federal courts use notice pleading where you just need to give fair notice of your claim, New York requires fact pleading under CPLR 3013. This means your complaint must contain sufficient factual allegations to give your opponent fair notice of what you're claiming and why. Don't just say defendant was negligent. Tell the court exactly what the defendant did wrong, when they did it, where it happened, and how it caused your damages. Be specific, be detailed, be factual. Now let's talk about the killer, service of process under CPLR 308. You can have the best case in the world, but if you don't properly serve the defendant, your case dies before it starts. For individuals, you have several options. Personal delivery under CPLR 308, 1, is your gold standard. Hand the papers directly to the defendant. But if that's not possible, you can use substitute service under CPLR 308, 2. This means delivering to a person of suitable age and discretion at the defendant's residence or business, but you must also mail a copy. Here's where people mess up. The person receiving service must be of suitable age and discretion. That means someone who appears to be at least 18 and seems responsible enough to ensure the defendant gets the papers. A random neighbor or a child won't cut it. If substitute service fails, you can try nail and mail under CPLR 308-4. Affix the papers to the door of defendant's residence or business, then mail a copy. But this requires court permission first, and you must show that personal and substitute service were attempted and failed. For corporations, use CPLR 311. You can serve an officer, director, managing agent, or designated agent. The Secretary of State can accept service for many corporations if you can't locate the proper person. Let me tell you about the fatal errors I've seen. First, insufficient service affidavits. Your process server must provide detailed affidavits describing exactly how, when, and where service was made and who received the papers. Generic or conclusory affidavits will get your case dismissed. Second, serving the wrong entity. Make sure you're suing the correct legal entity and serving the right person. If you sue ABC Company, but the real entity is ABC Company, Inc., you've got problems. Third, improper corporate service. Serving a low-level employee instead of an officer or authorized agent won't work. Do your homework and identify the proper person to serve. Here's my practical advice. Always use licensed process servers who know New York rules. Get detailed affidavits that include descriptions of the person served. When in doubt about corporate entities, check the Secretary of State's database to confirm the exact legal name and registered agent. For pleadings, use the standard forms available from the court system, but customize them with your specific facts. Don't rely on generic templates that don't match your situation. Remember, you can cure defective service under CPLR 306B if you act quickly, but prevention is better than cure. Get it right the first time and your case survives to fight another day. Judge Torres will now explain how to make sure you're fighting in the right courthouse.
As a judge, I've seen lawyers lose winnable cases simply because they filed in the wrong court or county. I'm retired New York Supreme Court Justice Michael Torres, And after 20 years on the bench, I can tell you that jurisdiction and venue mistakes are both common and devastating. Let me teach you how to get this right from the start. First, understand that jurisdiction is about the court's power over the defendant, while venue is about the proper location within the court system. Get either wrong and your case can be dismissed or transferred, costing you time, money, and momentum. For personal jurisdiction in New York, you need one of three things: the defendant's consent, their presence in the state, or a basis for long-arm jurisdiction under CPLR 302. Consent is easy. If the defendant appears and argues the merits without challenging jurisdiction, they've consented. Presence means the defendant was physically served while in New York regardless of whether they live here. But most cases rely on long-arm jurisdiction under CPLR 302. This statute allows New York courts to exercise jurisdiction over non-residents in specific situations. The most common is when the defendant transacts business in New York and your claim arises from that business. Here's what I've seen work and what doesn't. Simply having a website that New York residents can access isn't enough for jurisdiction, but actively soliciting business in New York, maintaining regular business relationships here, or causing injury in New York through actions taken outside the state can establish jurisdiction. The key is the connection between the defendant's New York activities and your specific claim. The activities must be substantial, not isolated, and your lawsuit must arise from or relate to those activities. Now for venue under CPLR 503, this determines which county within New York should hear your case. For individuals, venue is proper in the county where the defendant resides when you file suit. For corporations, it's the county where they have their principal place of business. You can also file where the cause of action arose. This is powerful because it lets you choose a favorable county if the defendant acted there. A car accident in Albany means you can sue in Albany County, even if the defendant lives in Buffalo. Here's strategic thinking from the bench. Different counties have different characteristics. Some move cases faster, some have more plaintiff-friendly juries, some have judges with particular expertise. Venue choice can influence your case outcome significantly, but be careful of change of venue motions under CPLR 510. If venue is improper, the defendant can force a transfer. Even if venue is proper, they can seek transfer for the convenience of witnesses or in the interest of justice. I've granted change of venue when all the witnesses and evidence were in a different county, when the case would create local prejudice, or when the chosen county had no real connection to the dispute. From the bench, I can tell you that judges notice when lawyers file in inappropriate venues for strategic advantage. It doesn't create a good first impression, and it wastes judicial resources. My practical advice: file where you have the strongest jurisdictional basis and the most logical venue connection. Don't get cute trying to forum shop unless you have a legitimate basis. For jurisdiction, document the defendant's New York connections carefully. For venue, choose the most defensible county and be prepared to explain why it's appropriate. Remember, these decisions happen at the beginning of your case when first impressions matter most. Get them right, and you're fighting on solid ground. Get them wrong, and you're playing defense from day one. Attorney Rodriguez will now show you how to use New York's discovery rules to build your winning case.
Discovery in New York State Court is both more limited and more strategic than federal practice. I'm Lisa Rodriguez, Senior Litigation Partner with 15 years focusing on discovery strategy, and I'm going to show you how to use New York's unique discovery rules to build winning cases. The first thing you need to understand is that New York discovery is more restrictive than federal court. We don't have the broad discovery fishing expeditions you see under Federal Rule 26. Instead, CPLR 3101 requires that discovery be material and necessary to the prosecution or defense of an action. This means every discovery request must have a clear purpose tied to proving or disproving a claim or defense. Judges will shut down fishing expeditions quickly, so your discovery strategy needs to be focused and methodical. Let's start with mandatory disclosure under CPLR 3101. Unlike federal practice, New York doesn't require extensive automatic disclosures, but what you must disclose includes the names and addresses of witnesses with knowledge of relevant facts, and you must supplement these disclosures if you learn of additional witnesses. This creates both opportunities and traps. Smart lawyers use the witness disclosure requirements to identify key players early, but failing to supplement when you discover new witnesses can get evidence excluded at trial. Now for the discovery devices themselves. Depositions under CPLR 3107 are your most powerful tool, but they're also expensive and time-consuming. In New York, you generally get one deposition per adverse party without court permission. Additional depositions require a court order showing good cause. Here's a strategic tip from my practice. Make your depositions count. Do thorough document discovery first so you can confront witnesses with their own papers. A deposition without supporting documents is often a wasted opportunity. For document production under CPLR 3120, be specific in your requests. New York courts won't tolerate overly broad demands for all documents relating to something. Define your document categories precisely and tie each request to specific claims or defenses. Electronic discovery in New York follows the same proportionality principles as federal court, but state judges are often less familiar with e-discovery complexities. This means you need to educate the court about preservation requirements, search methodologies, and cost considerations. When dealing with e-discovery, address preservation immediately. Send litigation hold notices right after filing or before filing if you anticipate litigation. Document your preservation efforts because you'll need to prove compliance if challenged. Interrogatories under CPLR 3130 are limited to 25 questions, including subparts. Use them strategically to lock down positions before depositions and to identify witnesses and documents. Don't waste interrogatories on information you can get from public records. Here's where many lawyers fail. They treat interrogatories as afterthoughts. I use them as roadmaps for depositions. Ask about the basis for denials, the identity of witnesses, and the location of key documents. Then use those answers to make depositions surgical. Physical and mental examinations under CPLR 3121 require court orders and good cause. You need to show that the condition is genuinely in controversy and that the examination will provide relevant evidence. Independent medical examinations in personal injury cases are routine, but mental examinations require stronger justification. Discovery disputes are inevitable, but how you handle them matters. New York requires a good faith effort to resolve disputes before bringing motions. Document your meat and confer efforts thoroughly. Courts want to see that you tried to work things out. When you do bring discovery motions, be specific about what you need and why. Don't just say the information is relevant. Explain how it will help prove or disprove specific elements of your claims or defenses. Protective orders under CPLR 3103 are powerful tools for sensitive information. Use them proactively when dealing with trade secrets, confidential business information, or personal medical records. It's easier to get a protective order at the beginning than to put the genie back in the bottle after disclosure. Here's my practice tip for cost management. Prioritize your discovery. Start with the most important witnesses and documents. You may not get everything you want, so make sure you get what you need most. For timing, remember that discovery in New York is tied to the note of issue. You generally can't conduct discovery after filing your note of issue without court permission. Plan backwards from your trial date and leave buffer time for disputes and delays. My final advice, discovery is storytelling preparation. Every deposition question, every document request, every interrogatory should help you tell a clearer, more compelling story at trial. If a discovery request doesn't advance your narrative, don't make it. Mediator Kim will now show you how to use motion practice to win your case before trial even begins.
Motions win or lose cases before you ever get to trial. Here's how to make them work. I'm David Kim, former litigator turned mediator, and I've seen hundreds of cases decided on motion practice alone. Let me share what separates winning motions from expensive failures. The two motions that matter most in New York practice are motions to dismiss under CPLR 3211 and summary judgment motions under CPLR 3212. Master these and you control the litigation battlefield. Let's start with motions to dismiss. CPLR 3211 gives you 7 grounds to attack a complaint, but 3 dominate practice: failure to state a cause of action, lack of subject matter jurisdiction, and documentary evidence that conclusively disposes of the claim. Here's the key insight from my litigation days. Timing is everything. You generally waive CPLR 3211 defenses if you don't raise them in your first responsive pleading or motion. Don't file an answer first and then try to move to dismiss. You've likely waived your best arguments. For failure to state a cause of action under CPLR 3211A7, remember that New York uses fact pleading. The complaint must contain sufficient factual allegations to give fair notice of the claim and its basis. But here's the trap. You can only consider the complaint itself, not outside evidence. The documentary evidence motion under CPLR 3211A1 is more powerful because you can use documents to kill the case. But the documents must utterly refute the complaint's allegations. A contract that contradicts the plaintiff's version of events, a deed that shows they don't own the property, a video that disproves their accident claim. From my mediation experience, I can tell you that a strong motion to dismiss changes settlement dynamics immediately. Plaintiffs who thought they had leverage suddenly face case dismissal, while defendants gain enormous negotiating power. Now for summary judgment under CPLR 3212. This is where cases really get decided. The standard is whether there are triable issues of material fact. If no reasonable jury could find for the non-moving party based on the evidence, summary judgment is appropriate. Here's what I learned from winning and losing summary judgment motions. The burden-shifting dance is crucial. The moving party must establish their entitlement to judgment as a matter of law. Only then does the burden shift to the opponent to show triable issues of fact. Support your motion with admissible evidence. Affidavits, deposition testimony, documents, expert reports, but make sure it's admissible at trial. I've seen great motions fail because lawyers relied on inadmissible hearsay or speculation. The reply brief is where summary judgment motions are often won or lost. Don't just repeat your opening arguments. Address the specific factual disputes your opponent raised and explain why they don't create genuine triable issues. Cross motions for summary judgment are common in New York practice. When both sides move for summary judgment on the same issue, they're essentially saying, "Judge, decide this case on the papers." This can be powerful when the facts are undisputed and only legal questions remain. Motion format matters more than lawyers think. Your notice of motion must comply with CPLR 2214. State exactly what relief you're seeking and the grounds for your motion. Attach your supporting papers properly. Follow local court rules for page limits and formatting. Here's a practice tip. Include a short statement of material facts with your summary judgment motion. Number each fact and cite to supporting evidence. This makes it easy for the court to follow your argument and hard for your opponent to create confusion. Oral argument can make or break your motion. In New York, you're not automatically entitled to oral argument, but you can request it. Use oral argument to clarify complex issues, address the court's concerns, and distinguish unfavorable cases. From the mediator's chair, I see how motion practice affects settlement negotiations. A pending summary judgment motion creates urgency. Parties who might otherwise drag out discovery suddenly want to talk settlement before the motion is decided. But here's the strategic consideration. Sometimes the threat of a motion is more powerful than filing it. If you have a strong dispositive motion, use it to pressure settlement discussions. Once you file and lose, that leverage disappears. My advice for motion practice strategy: be selective. Don't file motions just because you can. File motions you can win, and that advance your client's goals. A weak motion that gets denied hurts your credibility for the rest of the case. For motion to dismiss practice, file early and file comprehensively. Raise all available defenses because you may not get another chance. For summary judgment, wait until discovery gives you the evidence you need to win decisively. Remember that motion practice is expensive. Budget for the time to research, write, and argue properly. A half-hearted motion is worse than no motion at all. Attorney Washington will now show you how to prepare for trial when your motions don't end the case.
Trial preparation in New York starts months before you enter the courtroom. I'm Rachel Washington, trial attorney with 15 years of New York courtroom experience, and I'm going to show you how to prepare for trial the right way, because by the time you're standing before a judge, it's too late to fix your mistakes. The foundation of trial preparation is your note of issue and certificate of readiness. Under CPLR 3402, you cannot get a trial date without filing these documents, and filing them prematurely can hurt your case. The certificate of readiness is your sworn statement that the case is ready for trial, that discovery is complete, all parties are joined, and there are no outstanding motions. Here's what trips up many lawyers. You cannot conduct discovery after filing your note of issue without court permission. File too early, and you're stuck without the evidence you need. File too late and you delay your trial date, sometimes by months or years depending on the court's calendar. My practice tip: have a discovery completion checklist. Have you deposed all key witnesses? Have you obtained all necessary documents? Have you retained and prepared your experts? Only file your note of issue when you can honestly certify the case is ready. Once your note of issue is filed, you'll be assigned to a trial part and given a compliance conference date. This conference is crucial. It's where trial dates are set and pretrial issues are resolved. Come prepared with realistic time estimates and any scheduling conflicts documented. Now let's talk about jury selection, because New York practice differs significantly from federal court. In state court, the judge typically conducts voir dire, not the lawyers. You submit proposed questions, but the judge controls the process. Prepare your jury questionnaire carefully. Focus on bias that affects your specific case. Personal injury cases need questions about medical experience and insurance work. Contract disputes need questions about business ownership. Don't submit generic questions. Tailor them to your case theory. During voir dire, pay attention to body language and tone, not just answers. Jurors often say what they think the judge wants to hear. Look for hesitation, defensiveness, or overly eager responses. These tell you more than the words themselves. For challenges, you get unlimited challenges for cause if you can show actual bias. Peremptory challenges are limited, typically 6 per side in Supreme Court cases. Use them strategically, not just because you have a gut feeling about someone. Evidence preparation requires understanding New York's evidence rules, which closely follow the federal rules but have important differences. Business records exceptions under CPLR 4518 are broader than federal equivalents. Hearsay rules have New York-specific applications you need to master. Expert witness disclosure follows CPLR 3101D. You must disclose the subject matter of your expert's testimony and the substance of their opinion. This isn't as detailed as federal practice, but it's enough to prevent surprise testimony at trial. Here's my trial preparation system. Create 3 timelines. First, a chronological timeline of the facts. Second, a legal timeline showing when causes of action accrued and statutes of limitations ran. Third, a discovery timeline showing what evidence supports each element of your claims or defenses. Document organization is critical. I use trial notebooks with sections for opening statement, witness outlines, exhibit lists, jury instructions, and closing argument notes. Each witness gets their own section with deposition excerpts, document references, and examination outlines. Settlement conferences are mandatory in most New York courts before trial. Don't treat these as formalities. Prepare settlement statements that tell your story persuasively. Include damages calculations, key evidence summaries, and realistic settlement ranges. Judges appreciate lawyers who come to settlement conferences prepared to negotiate seriously. Bring decision makers with authority to settle. Have your client present or immediately available by phone. For trial scheduling, understand that New York courts operate differently than federal courts. Trial calendars are often crowded and adjournments are common. Build flexibility into your schedule and your client's expectations. The week before trial, conduct witness preparation sessions. Review testimony, practice difficult questions, and discuss courtroom procedures. Don't coach witnesses on what to say. Prepare them for how to say it clearly and credibly. Final trial preparation includes exhibit preparation with pre-marked exhibit stickers, witness subpoenas served properly in advance, and opening statement practice. I rehearse opening statements out loud multiple times because what sounds good in your head often doesn't work in the courtroom. Day of trial logistics matter. Arrive early to check technology, organize your materials, and meet with your client. First impressions start when you walk into the courthouse, not when trial begins. My final advice, prepare for trial as if you're definitely going to trial, but remain open to settlement until the jury is sworn. Most cases settle, but the ones that don't require thorough preparation to succeed. Professor Mitchell will now explain what happens when your trial ends, whether in victory or defeat.
Your case doesn't end with the verdict. Understanding post-trial options is crucial. I'm Professor James Mitchell, Appellate Specialist and Law Professor, and I'm going to show you how to protect your victory or salvage defeat through New York's post-trial and appellate procedures. The most important deadline in appellate practice is the 30-day rule. You have exactly 30 days from entry of judgment to file your notice of appeal, not from the verdict, not from when you receive notice, from when the judgment is entered in the clerk's office. Miss this deadline, and your appeal rights are gone forever. But before you appeal, consider post-trial motions that might give you the relief you need without the expense and delay of an appeal. Motion for judgment, notwithstanding the verdict under CPLR 4404, lets you challenge a jury verdict that no reasonable jury could have reached based on the evidence. The JNOV standard is high. You must show that the evidence so preponderated in your favor that the verdict could not have been reached on any fair interpretation of the evidence. It's not enough that you disagree with the jury's decision. You need to demonstrate that reasonable minds could not differ. Motion for a new trial under CPLR 4404 gives you broader grounds. Errors in jury instruction, misconduct by opposing counsel, newly discovered evidence, or a verdict that's against the weight of the evidence can all justify a new trial. The weight of the evidence standard is more forgiving than the JNOV standard. Here's a strategic consideration from my appellate practice. Sometimes a new trial motion is better than an appeal. New trials happen in months, not years. Appeals can take 2 years or more, and you might win the appeal only to face a new trial anyway. For appeals, Understand New York's appellate structure. Most appeals go to the appellate division of the department where your case was tried. The Court of Appeals is discretionary for most cases. They choose which cases to hear based on statewide importance. Not every order is appealable. Final judgments are always appealable, but interlocutory orders require specific authorization. CPLR 5701 lists appealable orders. But the key principle is that you generally cannot appeal until the case is finished, unless the order involves constitutional rights or effectively ends the litigation. The record on appeal is crucial and expensive. You need transcripts of all proceedings you want the appellate court to consider. Court reporters charge by the page, and trial transcripts can cost thousands of dollars. Budget for this early and order transcripts promptly after adverse rulings. Brief writing separates good appellate lawyers from great ones. Your statement of facts must be accurate and persuasive while acknowledging unfavorable evidence. Don't bury important facts in footnotes or hope the court won't notice problems in your case. For your legal argument, start with your strongest point. Appellate judges often decide cases based on the first issue they find dispositive. Lead with winners, not warm-up arguments. Standard of review controls everything in appellate practice. Questions of law get de novo review. The appellate court gives no deference to the trial court. Factual findings get clearly erroneous review, which is very deferential. Discretionary rulings like evidence decisions get abuse of discretion review. Frame your appeal around the most favorable standard of review. If you're challenging a legal ruling, emphasize that it's a pure question of law deserving no deference. If you're attacking factual findings, you need to show clear error supported by the record. Oral argument in the appellate division is typically brief, often just 15 minutes per side. Prepare for interruptions and questions. Don't read your brief to the court. Use the time to address their concerns and emphasize your strongest points. Here's what I've learned from 20 years of appellate practice. Most appeals are lost, not won. The appellate court starts with a presumption that the trial court got it right. Your job is to overcome that presumption with compelling legal arguments and clear record citations. Enforcement of judgments requires its own expertise. Winning a judgment means nothing if you can't collect it. New York gives you powerful collection tools, restraining notices, asset discovery, and contempt proceedings, but you must use them correctly. Restraining notices under CPLR 5222 freeze bank accounts and other assets, but they're only effective if served before the debtor moves money. Asset discovery under CPLR 5223 lets you examine the judgment debtor about their finances under oath. For contempt proceedings, you need to show willful violation of a court order. Document everything: missed payments, hidden assets, violation of disclosure orders. Courts take contempt seriously, but only when you prove your case clearly. My final advice on post-trial strategy: plan your post-trial options during trial. Preserve objections for appeal, document misconduct for new trial motions, and gather asset information for enforcement. The decisions you make during trial determine your post-trial options. Remember that most cases end with trial, not appeal. But when appeals are necessary, thorough preparation and strategic thinking can turn defeats into victories or protect hard-won trial wins. That completes our comprehensive tour of New York civil procedure from filing to final resolution.
Ho, ho, ho. Well, my ambitious legal scholars, you've just received quite a gift, haven't you? You've learned from some of the finest legal minds in New York. Professor Chen's pleading expertise, Judge Torres' jurisdictional wisdom, Attorney Rodriguez's discovery strategies, Mediator Kim's motion practice mastery, Attorney Washington's trial preparation skills, and Professor Mitchell's appellate knowledge. That's the equivalent of years of expensive legal education, wrapped up and delivered to you in under 30 minutes. Now that's what I call Christmas magic. But remember, knowledge without action is just expensive entertainment. Take what you've learned today and put it to work. Whether you're filing your first complaint, preparing for your first deposition, or arguing your first motion, you now have the tools to succeed. You've been very good students this year, so you've earned a permanent spot on my nice list of educated legal professionals. And because it's always Christmas at Legalis Law School, we have more gifts waiting for you. Check out our complete course catalog for advanced training in federal practice, litigation strategy, and specialized areas of law. Subscribe to our channel so you never miss new courses, and share this gift of knowledge with other legal professionals who need it. Remember, every lawyer who succeeds makes the entire profession stronger. So go out there, use what you've learned, and make us proud. Until next time, this is Professor Albert J. Legalis reminding you that at Legalis Law School, the spirit of learning never ends. Ho, 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 and happy lawyering.